Hello, IRO friends and colleagues. So for those of you who don't know me, my name is Nicole Upano. I'm NAA's AVP of Housing Policy and Regulatory Affairs, and I'm here to give you this year's legislative and regulatory update. It's really nice to be connected with many of you again. If you can believe it, this is my 4th year as an IRO Summit speaker, and it's an honor and a privilege to be part of this event and to be asked back year after year. So before I delve into the meat of my program, I would be remiss if I did not ask you to please take a moment and take in NAA's antitrust compliance and legal disclaimer. Thank you. My goal today is to call attention to big changes in 2024 that will impact your business and forecast significant housing policy changes in 2025 at all levels of government. And that is, we're coming at it from NAA's national perspective. So please do keep that in mind. We could stay here all day and talk about all of the state and local issues that are happening across the country. So let's start with our congressional advocacy. So for those of you who don't know or need a refresher, congressional sessions occur in 2-year cycles, and we're coming up on the tail end of the 118th Congress. As legislative days dwindle before the lame duck session, NAA continues its work to advance its 3 proactive legislative priorities. First, we want to make clear that the federal CARES Act pre-eviction notice requirement ended when the CARES Act eviction moratorium expired in, you guessed it, 2020. It's long past time to pass the RESPECT Act through Congress and eliminate ambiguity in current law, which allows this issue, the federal 30-day notice requirement for covered properties, to remain a contested issue in courts today. As I said, it's been 4 years since this temporary pandemic-related requirement ended. We must return authority on this issue to the states. In terms of where we are on this bill, this bipartisan piece of legislation was included in the House HUD appropriations bill, and we're hoping to pin it to any final appropriations package that comes out of the Congress before the end of this year. Our second objective is to lower local barriers to development. Resolving the nation's undersupply crisis is the best way to take pressure off of rents and ease renters' housing affordability challenges. And this is where federal policymakers can come in and make the most impact. We want to work with Congress to smooth the road for development. And the YIMBY Act does just that. It requires local governments to report on how they are lowering barriers, encouraging them to adopt tested pro-housing policies like expanding by right development, reducing minimum lot sizes and parking requirements, and streamlining permitting. This focuses federal dollars and federal powers on building and preserving affordable housing. This bill is, as the last one, bipartisan by wide margins and is well positioned to be passed before the end of the year. Last but not least, our third federal legislative priority for this session of Congress is to make meaningful improvements to the Section 8 Housing Choice Voucher Program. We want to make it more attractive to housing providers and thus increase quality housing options for participating renters. In our view, source of income mandates intended to require housing providers to accept housing choice vouchers are not the right policy solution to accomplish this goal. The Choice Act is. The Choice Act empowers PHAs to adopt tested best practices like implementing a risk mitigation fund to help renters with their security deposit needs. This also helps housing providers manage their potential financial risk of participating in the program. The bill also empowers PHAs to hire dedicated landlord liaisons and fund incentives for housing providers to encourage them to add more units to the program. This bill helps public housing authorities to administer the program in ways that provide participating housing providers and residents with better support throughout the leasing process and through the life cycle of the tenancy. Currently, there's wide variation in how more than 3,000, if you can believe it, 3,000 public housing authorities manage the program across the country. And we at NAA, we want to be part of the solution. We want industry to be part of the solution to address these participation barriers head on. NAA continues its proactive work and defense of the industry on Capitol Hill. There were 54 noteworthy bills that could impact rental housing providers nationally if they passed. To name a few, you really should keep an eye on the following as concepts: the Preventing Algorithmic Collusion Act, the Preventing the Algorithmic Facilitation of Rental Housing Cartels Act, the HART Act, and potentially the introduction of the Fair Future Act. Let's dig into these proposals a bit more. While the Preventing Collusion Act focuses on making clear the use of revenue management systems are federal antitrust violations, the Cartels Act is much more prescriptive in its regulation of the use of revenue management. This bill makes it unlawful for rental housing providers to contract with companies that provide rent-setting tools. The bill sponsors argue that this amounts to illegal price coordination among providers and this bill designates these arrangements as per se violations of federal antitrust laws. Two sub-issues that are emerging in terms of attempts to regulate revenue management is one, alleged price coordination among housing providers, and two, that the federal government, and now we're seeing state and local policymakers get into the game, they are taking issue with mergers of companies that create an increased risk of materially lessening competition for renters, for consumers. This bill targets both, as well as giving plaintiffs stronger rights to bring lawsuits under the Act, for example, as it relates to bypassing arbitration. Third, to put on your watch list is the HART Act, which would require institutional investors that buy homes in bulk to report sizable investments to federal regulators. This could potentially increase your legal risk and your legal costs. While this may not affect many of you from an IRO perspective, it is certainly worth noting in the context of emerging threats to the industry. The fourth bill that I'd like to put on your list is renter and criminal justice advocates are taking strong issue with what's referred to as the Thurman Amendment. This allows housing providers to categorically deny housing to applicants convicted of drug distribution or manufacturing of a controlled substance. As you know, HUD says that housing providers must engage in an individualized assessment in the screening process and that blanket categorical bans violate the Fair Housing Act. The Thurman Amendment is an exemption to these requirements. The Fair Future Act would eliminate this exemption from the Federal Fair Housing Act, which allows for these categorical denials and opens up a greater possibility, again, of litigation or increased legal costs for housing providers to defend against these claims. These policy approaches are getting a lot of attention. That's why I suggested that you think of these and keep an eye out for them as concepts. While there are no avenues for passage through Congress at this time, we fully expect these proposals to come back in the next Congress and be the subject of hearings and conversation at the federal level in the coming year. While we're forecasting that Congress will focus on tax reform next year, it's widely expected to be the tax Super Bowl. NAA continues its work to defend the industry against these emerging challenges, and we continue our work to ensure that housing providers have a seat at the table while all of these conversations are happening. Just to put this into perspective, between Congress, the White House, and federal agencies, NAA has already sent up 50 letters ourselves or with our coalition partners just to date in 2024. If that gives you any idea of the scope of NAA's federal advocacy and the dozens of issues that we work on your behalf. Let's pivot now to our federal regulatory update, where there's a lot of action happening. So as you all know, and I've certainly reported about this before, divided government in Congress has left President Biden with few avenues to advance his housing priorities. So federal agency activity is really where it's at. HUD has been busy during the first half of the year, and I know there's a lot to digest on this page, but 3 things that I want to make sure that I put on your radar is that HUD capped rent increases with an absolute cap of 10% for HUD-assisted housing. This also impacts LIHTC properties because the increases are tied to HUD's income limits. You should also be aware that they published a one-stop shop on their website to help advocates combat source of income discrimination. I referred to this type of policy approach before. It's intended to require housing providers to participate in the Section 8 program. You may be asking yourself, why should you care about source of income if it's not a protected class at the federal level or at the state or local level in your neck of the woods? Well, HUD is citing a February 2024 memo, which states that nonprofits that receive HUD funding may use the dollars they receive from HUD to test whether you're accepting Section 8. And if these denials amount to violations of fair housing laws. They're looking at this from the perspective of either violating the Federal Fair Housing Act as a disparate impact related matter. That's when a neutral policy has a discriminatory impact, or through state or local source of income laws. If you operate in a state that preempted local source of income mandates, you may not be immune to scrutiny. Specifically, how you approach denials of housing applications by Section 8 Housing Choice Voucher recipients. So we really highly encourage you to contact your attorney and rely on your state and local apartment association teams to help you better understand your fair housing compliance responsibilities. Other news that you should be aware of, HUD is getting into the game of federal building code requirements for certain types of new construction or rehabilitation that benefits from HUD programs. This is a major challenge for housing providers that participate and is widely expected to impact housing providers in 44 states because these federal code requirements that HUD would like to implement are only required in states' building codes in a handful of places. I lied, it's not 3, it's going to be 4, but for many of you who participate in HUD programs or benefit from HUD assistance, we did want to make sure that you are aware that HUD did move its Inspire compliance deadline for public housing authorities to October 1, 2025. It previously was October 1, 2024, to require PHAs to do Inspire inspections for housing choice voucher housing, project-based voucher housing, and other types of HUD-assisted programs, but that deadline has now been moved. Some PHAs may extend their testing phase because of this compliance deadline change. So you will hopefully have more time to get up to speed on new Inspire inspections requirements. If you didn't catch the training at Apartmentalize either last year or this year, you can count on NAA to continue to offer education for industry professionals so you feel prepared for your first Inspire inspection. So keep an eye out for that, or please do check out the training that's being offered as part of the summit this year. Every little bit helps. These are not just housing providers, but inspectors as well. Everyone is learning these new requirements, so it's going to take some time. Because I'm here to be not just the bearer of bad news, I also wanted to call your attention to impactful work that NAA is doing to ensure that industry leaders can connect directly with policymakers. Specifically, we're talking about improving the housing provider experience with the Section 8 Housing Choice Voucher Program. This year, NAA is proudly engaging in a year-long partnership with HUD and bringing the head of the Housing Choice Voucher Program to a city near you. If you participated in HUD's landlord listening sessions under the Trump administration, these events will differ. They'll be a bit more intimate versus the previous town hall setting because we want to encourage fruitful discussions about where stakeholders from all sides can find common ground and meaningfully improve the program. As we mentioned before, we want to take pressure off of folks who think that source of income mandates are the solution. We disagree. And instead, we want to work directly with our network of state and local apartment associations on these events throughout the country because we want to be part of the solution and instead of part of the problem. We are so appreciative to have a strong partner in HUD and with PDAS Minacchio. If you're interested in participating or you'd like to learn more, please do contact me. Now, for anyone who has a Fannie Mae or Freddie Mac backed mortgage on your property, this applies to you. As many of you may recall from previous presentations, NAA has continued to engage with FHFA, Fannie Mae, and Freddie Mac leaders who were charged with developing new requirements, what they see as potential tenant protections for enterprise-backed housing. We are pleased to announce that because of our advocacy, the agency is pursuing a measured approach in phase 1 of their agency directive. They had previously announced a commitment to explore rent control. Instead, multifamily borrowers through Fannie and Freddie will be required to provide their residents with the following. They're looking at a 30-day notice of rent increase, a 30-day notice of lease expiration, and a 5-day grace period for late fees. You do have some time to better understand your compliance responsibilities and get up to speed, since these apply to new loan applications, forward-facing only, beginning in February 2025. I've included the links to Fannie and Freddie's sets of standards so you can help get yourself up to speed, but please do feel free to continue to use NAA as a resource. So a couple items worth knowing now. These requirements will apply, as I said, to new loan applications in February 2025. They'll apply to new leases and renewals, and multifamily borrowers will be required to inform residents in writing that the standards are now in place at the property and apply to all residents, regardless of whether they are included in individual leases. There are no specific deadlines for implementing the standards at rental communities. There are specific deadlines for implementation, but there is no specific language prescribed by FHFA, Fannie, or Freddie for leases. Keep in mind, you may be asking yourself, how will this be enforced? You should also use your loan servicer as a resource for these new requirements. They will be responsible for monitoring your compliance. So this is not the end of the story. As I said, this is just phase 1. We're continuing our advocacy with FHFA and the enterprises on this issue as solutions like rent control, just cause eviction, and other potentially damaging policies remain on the table as part of a potential phase 2. We do not expect phase 2 to be announced before the election. Our intel suggests the agency is being very cautious about activities that could negatively impact the election, but please do stay tuned. So let's switch gears a bit and talk about new beneficial ownership requirements. So under the Corporate Transparency Act, which went into effect earlier this year, many small business owners, which includes independent rental owners, are required to file corporate transparency reports with what they're calling beneficial ownership information. For most businesses, the filing deadline is January 1, 2025. Those who fail to file by this deadline, or as we'll talk about later, fail to file updated information when necessary, could face up to 2 years in prison, fines of up to $10,000, or civil penalties of up to $591 per day. So you may be asking yourself, what's required of me? So businesses registered or established post January 1, 2024 must provide information regarding the business, its beneficial owners, and its quote-unquote company applicants. These company applicants are individuals or an individual that was involved in filing documents that created or registered your company with the Secretary of State or similar office. This could be your accountant or your lawyer, depending on their involvement in the filing. And you must also include information in the report about owners and applicants' names, addresses, birthdays, identification numbers like their license or passport number, and the jurisdiction of the documents. Businesses established before January 1 can omit information regarding company applicants and must only submit information on the business and beneficial owners. So who are beneficial owners, which is the more common requirement? Companies must disclose to the federal government any individual that's a beneficial owner if they directly or indirectly have a significant ownership stake in your company. Maybe asking yourself, that's pretty broad. Well, the threshold here is these individuals either have a major influence on the reporting company's decisions or operations, they own at least 25% of the company's shares, or have a similar level of control over the company's equity. You should also keep in mind that while the CTA does not require businesses to submit annual reports, the initial filing may not be the only time that you're required to submit. For example, if the responsibilities of beneficial owners change, then you must submit this updated information. I know that's a lot to take in, but we want to make sure that you can continue to use NAA as a resource in this area. We will be offering training to help IROs understand their unique compliance responsibilities leading up to the January 1, 2025 deadline. More information is coming on that front. In the meantime, I've included in this PowerPoint deck, the Chamber has a great resource for all small business owners. If you can believe it, there's more. NAA is still analyzing the impact of Biden administration activities through the end of the year, but you should continue to expect a push to lower costs and promote housing stability for renters. Their goal here is to encourage voters to choose a Dem ticket on Election Day. Here's what you can expect. We will continue our advocacy on all of these major federal issues. In July, President Biden announced his proposal, which would require housing providers with 50 units or more to cap rent increases at 5% or lose an important federal depreciation tax benefit. While it would sunset after 2 years and exempts new construction, substantial renovation, or rehabilitation, we do not believe this is the right approach to policy. Any form of rent control has perilous, devastating consequences, not just for housing providers, but for renters and their housing opportunity and access. This federal rent control proposal, it does require an act of Congress, and there are no paths forward for this approach currently, but depending on the fall elections, this proposal could be part of tax reform discussions in 2025. We will continue our advocacy with Congress and the administration to warn them of the perils of rent control and ensure the industry's voice is heard, no matter where this proposal goes in the process. I wanted to just take a moment also to thank all of you. We know that 2,000 NAA members contacted your members of Congress to urge your opposition as well. So we really do need to show a strong force in opposition to many of these proposals as federal policymakers and regulators are continuing to see just as much activity and support from the other side. It is worth noting that Democrat presidential candidate Harris expressed support for this proposal during one of her campaign spots, but you will notice she notably did not include it in her housing policy platform, despite advocates urging her to do so. Instead, she continues to shine a light on these other efforts on the screen to drastically increase affordable housing development and continue scrutiny of rent-setting tools that the Biden-Harris administration argues artificially inflate rents. So what else? Well, we are still waiting for the FTC to issue its so-called junk fees rule, which will likely establish federal disclosure requirements to inform renters of fees and other charges they should be expected to pay during their tenancy. This could have fundamentally changed how housing providers advertise, depending on how the FTC interprets disclosure required before the consumer consents to pay. If not properly disclosed per the rule, you should know that charging the fee would be prohibited. So this is a big deal to implement these kinds of federal fee disclosure requirements. We are cautiously optimistic that this rulemaking has been put on hold by the agency because of NAA's advocacy, as well as the overwhelming concerns from business owners across industries who'd be affected, and if you hadn't seen it, some recent legal news. The commission reported to the White House that the next action for this rulemaking is undetermined, so it does appear to be pushed off course of the normal rulemaking process. We do think that the Loper-Bright Supreme Court decision forced the FTC to change their thinking on this issue because the rule started out as an all-encompassing set of requirements for virtually all American businesses that offer goods and services. Loper-Bright certainly changes things, and it's likely that they're redrafting it. So it's less likely to be struck down in court if it were challenged. So we're keeping an eye on that as well, and continuing our conversations with federal regulators. We also know out there's a lot of concern about the proposed FCC rule, which would ban broadband bulk billing arrangements. Right now, you may have seen a lot of hype or a lot of conversation about this, but we really are still just operating on what's available via the FCC's press release. Despite their public comments indicating their intent to move quickly on this, we are still waiting for the notice of proposed rulemaking to be released from the FCC. This rulemaking, it does build on the FCC's efforts throughout the last couple of years to dismantle all partnership agreements between housing providers and internet service providers, and in its current form would impact or could impact managed Wi-Fi contracts. We are happy to report at this time, because NAA has engaged in direct advocacy with both Congress and FCC leadership in partnership with our sister organization, NMHC, that FCC Chair Rosenworcel has indicated that there is a loss in appetite to tackle such a contentious issue in the immediate near term. Remember, many federal agencies are being very conscientious about not negatively impacting the election at this point. We're getting very close. As I said, because of the industry's strong advocacy against the proposed approach to prohibiting bulk billing arrangements, we are seeing signals from the Commission leaning against imminent regulation, and instead we anticipate that they will pursue a sort of fact-finding effort like the FHFA's request for input. This will be about collecting data versus announcing strict regulations at first sight. So what else should you expect coming out of DC in 2024 and in 2025? Well, Vice President Harris and President Trump's housing platforms, as you can see, very much reflect their political leanings. Dems want to explore where they can intervene on behalf of renters and add regulation, versus President Trump's approach of focusing on deregulation. Either way, you can count on NAA as the voice of the rental housing industry, as your voice in DC, and will maintain continuity of our efforts no matter who takes power in January. As I mentioned, we want to make sure that industry has a seat at the table for all relevant federal policy discussions, and we're continuing conversations and setting up meetings with the Harris camp and the Trump camp to discuss their policy priorities and, their future plans. Between now and 2025, as I mentioned, don't expect the Biden administration to do anything that could upset the apple cart. We're getting dangerously very close to the election, and we're less and less likely to see any sort of policy-related October surprise. So I'd like to close today's presentation with NAA's take on state and local issues of national significance. Like I said at the start of this presentation, we could talk all day about what's happening at the state and local level, but we want to focus on the trends that we're seeing at the national level or that have national significance. So here's what you need to know on that front. So we want to make sure that you watch out for proponents' attempts to gain a foothold on rent control via rent control light type proposals. I'll give you the example of Colorado's law, which freezes rent increases after a declared natural disaster at the previous year's increase or 10%. This version of rent control light is starting to take hold, and from there, we often see rent control jurisdictions tighten the screws from there. New York, for example, their just cause law brings the rent control fight to eviction court. It essentially allows judges to decide whether a rent increase was unreasonable and if it should impact an eviction case for moving forward. That's another flavor of rent control that we're seeing out there. A couple other areas that we want to make sure to put on your radar. This issue, while there is a lot of state activity that's happening, it primarily remains a local issue. Keep in mind that on August 1st, Prince George's County, Maryland, signed into law a cap on rent increases of the lesser of 6% or 3% plus CPI. This law comes on the heels of other temporary rent increases passed in PG County, but there is one notable difference. This is permanent. Another way that proponents of rent control try to get a foothold is with arguing there is a temporary housing crisis that needs to be addressed, and then ultimately making these onerous requirements permanent. In St. Paul, Mayor Melvin Carter is proposing a change to the city's rent stabilization law passed in 2021, which would to permanently exempt all units built after December 31st, 2004. Since the enactment of the original ordinance, which left few exemptions to their 3% cap, the ordinance was updated the following year to provide a 20-year exemption for new construction and was retroactively applied to the existing housing stock. Another flavor of rent control that you should just be aware of, and as we said, no form of rent control is acceptable. It is our understanding that even with this new potential cutoff date, this still leaves over 90% of St. Paul's rental housing stock covered by the rent control policy. So it is not as much of a change as policymakers would like you to think it would be. Keep in mind, all of these flavors of rent control continue to proliferate all across the country. In California, you may have seen that Proposition 33 is back on the ballot this November, which would remove the state's limits on local powers to enact rent regulations. California is a unique place where there's a tension between state level limits on local power to enact rent control, as well as local power to enact certain types of rent controls. This would open up the floodgates for rent control and, of course, is of great concern to us. While all of this is happening, again, the fights continue at the local level. Salinas, California is currently considering a cap of between 2.5 to 2.75% or between 65 to 75% of the consumer price index. While we see local rent control battles rage on in 2024, as well as certainly the ballot measures, we do anticipate that the most heated discussions next year at the state level will be on targeting state level preemptions. That is the types of state controls that prevent local governments from enacting these policies. You'll see it in the places you think, but also keep an eye on unlikely locales like Michigan and Nevada. Another potential area of regulation at the state and local level is fee regulation. As we said, rental housing costs are a big issue for voters, and this is continuing to drive policy discussions. In Maine, to give you a sense of their flavor of this type of policy, their law would limit upfront housing costs, implement total cost and fee disclosures, and require at least 45 days notice before a rent or a fee increase. In Minnesota, which has led the charge in fee regulation policy at the state level, earlier this year, they required Minnesota housing providers to disclose all non-optional fees in the lease, despite there being no definition provided in statute. The sum total of rent and all non-optional fees are required to be described in the total monthly payment and be listed on the first page of the lease. There is not just an impact to leasing, but also impacting advertising in Minnesota as well. The law states that housing providers must disclose non-optional fees included with the total amount of rent in their advertisements. And in both leases and ads, they must disclose whether utilities are or are not included in the rent. So there are a lot of hitches out there to fee regulation policy. We certainly expect Minnesota's flavor to spread, as Virginia is the most recent state to adopt similar disclosure requirements. As with the federal junk fees rule and potential unintended consequences of fee disclosure policy, we are also keeping an eye on the fact that in Minnesota, for example, this law started out as a proposal to prohibit all non-refundable fees. And you'll see, as I said, not just fee disclosure requirements, but also legislation targeting housing providers and them being able to recover their actual costs. So keep that in mind as well. So much like the interest in revenue management at the federal level, this is a third area that we wanted to make sure to put on your radar. Similar conversations, like the federal level, are happening at the state and local levels of government. You may have seen that earlier this year, Colorado did successfully adopt new requirements that require high-risk AI systems to use reasonable care to protect consumers from potential algorithmic discrimination. That just recently went into effect. San Francisco is considering a proposal that appears to be the first of its kind, would prohibit the sale and use of any algorithmic devices that set, recommend, or advise on rents or manage occupancy levels for units in San Francisco. This bill did pass on first reading on July 30th and is awaiting final approval by the Board of Supervisors on September 3rd. Being that it is a first of its kind type of legislation in this area, in a very much emerging area of the law, we are watching this closely and working with our state and local association partners to support their advocacy efforts in this area. Couple other flavors of these types of proposals to regulate revenue management and rent setting tools. Illinois' proposal, which was just introduced last month, does not have any opportunity for passage in 24, and more so was introduced for policy discussion. That proposal specifically takes issue with tools that utilize non-public competitor data. So expect continued interest on that front as well, or that flavor of revenue management regulation policy. We do expect that this bill will be reintroduced in 2025. One other place before I close that I wanted to make sure I put on your radar is New Hampshire. New Hampshire's spin on this policy was to disincentivize the use of revenue management tools by establishing a presumption that the eviction case was pursued unlawfully if the housing provider used a rent setting tool to increase the rent in the eviction case that was ultimately not paid. This would result in dismissals of lawful eviction cases. So wanted to put that on your radar as well. There's no one policy that's being considered across the country. The federal, state, and local policymakers are considering all types of policy approaches to regulate revenue management, specifically rent setting tools. As I mentioned before, nothing is set in stone except for Colorado's law and potentially San Francisco if it reaches final passage. It's just really important to keep in mind that given the potential impacts to your business, that you understand the types of policy proposals that are being considered. So as I wrap up today, I just wanted to remind you that there are threads, as you can see throughout my presentation, threads of similar interest in issues at all levels of government. In an election year, electeds are focused on proposals that have the greatest impact in the shortest amount of time and address constituents' most pressing pain points. That's why you see there's so much interest in those top 3 issues at all levels of government this year. As I said, rental housing costs, they remain a top issue for voters and continue to drive policy discussions. In addition to the 3 you see at the top, you should also be aware on other types of legislation that impact broadband. I'll give you the example of San Francisco, which has had a longstanding ordinance prohibiting housing providers from interfering with renters in the city, their right to obtain services from an internet service provider of their choice. Most recently, there is now a statewide law in Colorado, which became effective last month, which prohibits rental housing providers from denying a broadband provider's access to the property to install the necessary infrastructure to ensure they're able to provide service. So that is yet another version or policy approach that's being considered to control renters' housing costs and give them more access to competitive pricing. Less common, but also wanted to make sure is on your radar, are other types of anti-displacement solutions. Right to renewal or just cause eviction requirements, which cut at the heart of housing providers' contractual right to non-renew. Those are catching fire, as well as Tenant Opportunity to Purchase Act legislation, which amounts to requiring tenants to have the right of first refusal before a rental property can be put up for sale. All right, so I know that was a lot to take in. We always try to pack these so full of information, and the housing policy landscape continues to change at an alarming rate. But hopefully you learned a thing or two today about what's happening at the federal, state, and local levels that could impact your business. And please do continue to use me as a resource. I'm always here to help. If you have any questions, as I said, the landscape is constantly changing, and we know it's hard to keep up with all of this activity. If you'd like to get more regular updates throughout the year and you're not tired of me yet, we hope you'll utilize NAA's resources that are available to you. We lead an advocacy and legal webinar every 3rd Wednesday of the month to keep you up to speed on what's happening across the country, and we develop content in our Apartment Advocate newsletter if you want a deeper dive on some of the policies that are being considered across the country. So in closing, again, thank you for making time today for this presentation. I'm really looking forward to connecting with some of you during Q&A, and hopefully you can continue to use this as a resource as new information comes about. Thanks for tuning in, and take care.